This presentation is brought to you by Synergy Business Advisors Noida, your trusted business Mitra. Can a liquidator be punished for contempt of court during liquidation proceedings? And what happens if a creditor believes the liquidator ignored a court order? In a significant judgment, the Delhi High Court addressed this issue in JFC Finance India Ltd versus Arvind Garg, Liquidator and others, involving the liquidator of Moser Baer Solar Ltd under the Insolvency and Bankruptcy Code 2016. This ruling clarifies when contempt proceedings can be initiated against insolvency professionals. Let us break down the case step by step. The dispute arose from the liquidation of Moser Baer Solar Ltd, which was undergoing proceedings under the Insolvency and Bankruptcy Code 2016. During liquidation, JFC Finance India Ltd, a stakeholder / creditor, had certain grievances regarding the auction. JFC Finance India Ltd, a stakeholder / creditor, had certain grievances regarding the actions of the liquidator. The liquidator appointed in the case was Arvind Garg. The creditor agreed that the liquidator did not comply with certain directions issued by the court. Because of this alleged non-compliance, the creditor filed a contempt petition before the Delhi High Court. The purpose of the contempt petition was to establish that the liquidator had willfully disobeyed the court's orders. The court had to examine several important legal questions. Number one, whether the action of the liquidator amounted to willful disobedience of a court order, whether contempt proceedings can be initiated against a liquidator performing duties under the IBC framework. Number three, whether disputes relating to liquidation should primarily be addressed before the NCLT rather than through contempt proceedings in the High Court. These questions were significant because they affect how insolvency professionals perform their duties during liquidation. Justice Sachin Datta made several key observations while analyzing the case. Contempt jurisdiction is strict and limited. The court emphasized that contempt proceedings cannot be invoked casually. To establish contempt, the petitioner must prove a clear court order existed, the respondent had knowledge of the order, there was willful and deliberate disobedience. If any of these elements are missing, contempt cannot be established. Liquidators perform statutory duties. The court acknowledged that liquidators appointed under the Insolvency and Bankruptcy Code 2016 operate within a statutory framework. They perform duties such as taking custody of assets, realizing and selling assets, distributing proceeds among creditors, managing claims and liquidation estate. These actions are generally performed under the supervision of National Company Law Tribunal. Therefore, not every disagreement with a liquidator's action or decision can automatically lead to contempt proceedings. Next, disputes in liquidation should be resolved through proper IBC remedies. The court noted that if a stakeholder is dissatisfied with the actions of a liquidator, the appropriate remedy usually lies with the insolvency framework. For example, approaching the National Company Law Tribunal filing appropriate applications under the IBC, contempt jurisdiction is not meant to replace statutory remedies available under the insolvency process. After examining the facts and submissions, the High Court concluded that there was no clear evidence of willful disobedience of the court's order. The conduct of the liquidator did not amount to civil contempt. The issues raised by the petitioner were more appropriately addressed within the IBC mechanism. As a result, the court dismissed the contempt petition filed by JFC Finance India Ltd against Arvind Garg. This case establishes several important legal principles. Number 1, contempt requires willful disobedience. A mere disagreement with the liquidator's action is not enough to establish contempt. Insolvency professionals have functional protection. Liquidators acting within the scope of their statutory duties under the Insolvency and Bankruptcy Code 2016 cannot easily be subjected to contempt proceedings. Number 3, NCLT is the primary forum for IBC disputes. Most disputes arising from liquidation proceedings should be addressed before the National Company Law Tribunal rather than invoking contempt proceedings. The decision is very important for insolvency professionals. It provides reassurance that good faith actions taken during liquidation will not easily attract contempt proceedings. For creditors, creditors must understand that IBC remedies should be used first before approaching constitutional courts. For law students and practitioners, the case clarifies the relationship between contempt jurisdiction and insolvency proceedings. This is C&IP Praveen Agrawal thanking you for watching. I hope this presentation will be helpful for you. Please subscribe to the channel for more such informative videos. Thank you.